Hello, good morning everyone, bom dia a todos. Meu nome é Lauro Parente e vamos dar início à 17ª Conferência Internacional de Arbitragem do Rio de Janeiro. Esse ano, por diversas razões, a gente teve que passar para o virtual, então eu queria agradecer a todos os conferencistas que se dispuseram a participar conosco, e principalmente a todos os nossos patrocinadores, que eu queria mencionar nominalmente, a Simonage Certeza Técnica, a Leste Litigation Finance, a Avantec Consultores, Cadenas Perícias e Arbitragens, Exato Perícia e Arbitragem, SWOT Global Consulting, Hormigon Act Consultoria, e ao Centro de Arbitragem CBMA, Centro Brasileiro de Mediação e Arbitragem, Alcance CBC, e a Câmara de Conciliação e Mediação e Arbitragem Fiesp, e a ANCHAM, Câmara de Mediação e Arbitragem da ANCHAM. Hoje o evento vai ser sobre construção. Eu vou ler rapidamente a biografia dos palestrantes. Luiz Fernando is a civil engineer that worked for more than 20 years in construction companies, some of them construction sites. In the last 11 years, he exclusively worked in arbitration, produces acting expert witness, tribunal expert, and part technical assistant. He is able to act as mediator and dispute board members. Mélida Hodgson is a partner head the firm New York arbitration practice. She practices in investor, state, and commercial arbitrators. Alejandro López Ortiz is admitted to the Paris Bar and Madrid Bar. Alejandro is partner to the Meyer Brown International Arbitration Practice of Paris office. He leads the Latin America arbitration practice of the firm. Simon Braithwaite is Senior Vice President of Dialis, with over 20 years experience focused on both domestic and international, public and private construction, engineer and infrastructure projects, providing advisor to service to this project in dispute. We're gonna give the word to the Mauricio Almeida Prado and Lauro Gama, both the academic coordinator to the conference. And thank you, Mauricio, thank you, Lauro, to be with them in these troubled times.
Bom dia a todos. Lauro, você está no mudo aí, você tem que desmudar.
Ok. Bom dia a todos. Bom dia, boa tarde, boa noite, good morning, good afternoon, good evening. Thank you to each and every one of you for being here with us today. Muito obrigado a todos e a cada um de vocês por estarem hoje conosco. Today marks our 16th Rio de Janeiro International Arbitration Conference, and we are proud to be able to host it virtually today with the help of Lauro Parente from CodeCorp. Hoje iniciamos a 16ª edição da Conferência Internacional de Arbitragem do Rio de Janeiro e temos a oportunidade de realizá-la remotamente com o suporte de Lauro Parente da CodeCorp. João Bosco Lee, who unfortunately has an arbitration hearing this week and is unable to join us, Mauricio Almeida Prado and I have set up an exciting conference program for you, which focus on the interaction of the law and technical issues in international commercial.
Você está no mudo de novo, Lauro. Voltou.
João Bosco Lee, que infelizmente não pôde estar conosco devido a uma audiência arbitral, Maurício Almeida Prado e eu montamos um programa desafiador para esta conferência e que lida com a interação entre o direito e questões técnicas na arbitragem internacional. All panels, with the exception of next Thursday's, 19th of November, will be held in English. Todos os painéis, com exceção da próxima quinta-feira, serão em inglês. And so I'll give the floor to Mauricio, who will introduce you to the next to the themes of this conference. Thank you.
Bom dia, pessoal. Na verdade, os painelistas já foram apresentados pelo Lauro Parente, né? We thank very much for all the panelists to be here today. I would just like to say that the idea of this conference is to debate cutting-edge issues on international arbitration. A ideia dessa conferência é sempre discutir questões de ponta na arbitragem comercial internacional, and that's the reason that we invite the most renowned experts to join the conference, to contribute with the conference. And the idea of the 3 panels is to discuss a very sensitive issue, that is the bridges or the clashes between technical issues, engineering issues, accounting issues, economic issues, and the law. We, the lawyers, we are used to discuss, debate, and apply the law. But what happens in the practice of international arbitration or in arbitration is that we have to apply correctly. So the numbers, the figures, we have to understand what the reality is of complex issues in order to properly apply the law. So the panelists were asked to debate how to deal with this dialogue between law and technical issues in a way we can be productive, we can have positive results, instead of a very traditional approach that would say the lawyers discuss and apply the law while the experts do their job, the technical experts, and each one in its self environment, and they don't talk each other. So we think that we have been discussing that this is a problem in litigation and in arbitration. So that's the whole idea of the conference, and we hope you have a very good day and enjoy the conference. I think we can now pass the word. We thank very much the sponsors, isn't it, Lauro? That are
one last word, Mauricio. The next conference has already a date. Please save it. It will be held on May 11th, 2021, and hopefully it will be held in person. A próxima conferência já tem uma data, é dia 11 de maio de 2021, e esperamos todos, será realizada no seu formato tradicional, ou seja, presencialmente. Essa era a minha palavra, tenhamos todos uma ótima conferência.
I think we can transfer the floor now to Luiz Fernando Alongi.
So, we are starting with the first panel, technical issues and the law in construction dispute. We do not intend to discuss any legal system in particular. We are interested in discussing the interaction between and law issues or professionals, practitioners acting together. Before we start with particular issues, I will try to start with the lawyer's perspective of expert role. Mélida, in general, what is your opinion about the expert role in arbitration? In a lawyer perspective, as party or arbitrator, what do you expect from the expert? Do you think in a interpretation, the expert knowledge could help the tribunal?
Thank you, Luiz Fernando, and thank you very much to the organizers, Lauro, João Bosco. It's such a pleasure for me to be here. I could see the little picture of Rio in the background when we started. I so wish it could be there, but I'm hoping that for the next one, I'll be able to be there live with you. It's certainly my honor and pleasure to be on this panel with such distinguished colleagues. Let me just say that from my perspective, the role of the expert is critical in construction. We all as lawyers tend to learn as we do more and more of these cases, but the role of the expert is clearly necessary, in my view, for the understanding of certain different kinds of technical disputes that can arise in different arbitrations, not only in construction arbitration, but also in mining and infrastructure, oil and gas, and obviously some health sciences. But in construction, I think it's particularly relevant. It's, and as I said, how critical the role and the advice of the technical expert is, to some extent, will depend on the lawyer. But I think that, well, I should say the lawyer and the arbitrators, but we'll get to that later. You know, if either the lawyer or the arbitrators, or lawyers and arbitrators, have a sufficient understanding or experience of the different concepts and issues that can arise, then the role of the expert may shift, but it's still a critical role. It may, once, you know, it's a little bit like trying to explain something to someone who's not understanding the same language. I think it's important that you have a base knowledge, but the expert is still going to be the expert. You know, I'm not going to be able, I can learn enough to explain to a tribunal, you know, why something is a 1,000-year event, or a 500-year event, or a 100-year event, or why you need to drill a certain way, or why the drill needs to be there before you can do the rest of the project. But the real technical ability and the ability to understand why the dispute is a live dispute, I think, has to come from the experts. You know, concepts such as engineering studies and why there's a dispute between perhaps a supervisor, an independent supervisor, or a regulator and the contractor. You know, those kinds of things come from the expertise that lawyers, I think, simply, you know, perhaps after 40 or 50 years of dealing with one specific type of construction, perhaps you gain that. But I think otherwise, it's a critical role, you know, understanding the effect of delays or different kinds of delays on a critical path. You know, what is a real critical path? Issues like that. You know, translating the effect on that critical path, or the effect of delays in general, on ultimately the issue why there is a dispute that has gone to arbitration, that is the issue of damages. You know, all of that requires true expertise, true technical expertise. You know, as counsel, what I'm looking for from an expert is clarity. I'm really looking for straight answers. Because I'm trying to assess the strength of the case that I have. And so I don't necessarily want to just hear the good news. If there's good news, that's great. But oftentimes we don't get to arbitration because one side has such a great case, right? You get to arbitration because there's a true dispute that independent third party or third parties are going to have to resolve. And so it's important when you're preparing a case to understand fully the sort of different permutations. I once had a technical expert sort of say, "Oh yeah, but well, you know, we didn't think that you know, there was a bit of evidence that actually was helpful to us." And it's like, right, but you know, the thing is, this is debated within the industry, and so we didn't think that was the kind of knowledge that you wanted, because it's not 100% sure, essentially. And it's sort of like, no, we need to understand as best we can as counsel. We need to understand all of the permutations, all of the issues, the good and the bad. So for me, it's clarity in terms of how the expert understands and defines the technical issues, particularly clarity in terms of the methodologies that are going to be employed, or the methodologies that were employed, and why those methodologies have led us to the point why one is wrong or one is quasi-wrong, and has led us to the point where we're in a live, expensive dispute, in essence. And as I said, weaknesses of both our methodology and options that our clients use, as well as the other sides. And I'm looking, you know, for accuracy. You know, I think we all, expect a certain level of commitment to excellence. And I have been on the side of finding out very shortly before a cross-examination that our experts made a mistake. And when you've learned a certain amount in order to get you to be able to cross-examine an expert, which is never easy, finding out that there were technical or mathematical mistakes made kind of guts you a little bit, because you really then are going in cold and having to figure out how do you adjust at that late stage. Moreover, how do you adjust to save that, if, you know, hopefully it's an issue that only affects a narrow technical dispute, but it may have an effect on all of the other elements. And so I think it's important for everyone to remember that we're always, you know, in my view, committed to excellence for our clients. And so everyone needs to have that level of commitment to excellence. You know, so in summary, I would say that as a lawyer, I'm looking for the expert to help me assess the strength of my case and to help me present my case as best as I can, clearly, accurately. But one thing I do want to say is I'm not looking for the expert to be another advocate. I think that doesn't help anybody. It doesn't help the client, certainly. Because arbitrators, particularly arbitrators with experience in the area, you know, can see through that, whether it be technical expertise or just having been an arbitrator for a long time. And so it doesn't help anybody if the expert feels that they need to be an advocate. It doesn't help anyone if the expert feels that, you know, their opinion is paramount and they can't adjust or recognize that there is another point of view, or that there may be issues that they didn't completely comprehend. So I think part of being really valuable to the lawyer is in all aspects, including when it affects, you know, an expert's own, you know, the reliability of an expert's own opinion, is needing that clarity, that commitment to accuracy, in my view. Luiz Fernando, you asked about, you know, helping the tribunal and how the expert can help the tribunal. You know, I think it's a similar analysis from looking at it from the perspective of the lawyer and looking at it from the arbitrator's perspective. It's a little, we start sort of where I just ended. You know, how can the expert help the arbitrator resolve the dispute? Most important thing is absolutely needing to be impartial and honest about the view. The expert is coming into it, whether you're hired by one side or another, you're coming into it to present a clear, accurate, honest, impartial view of what the issue is. You know, frankly, I think in a lot of respects, it's good if experts can agree on a lot of things and identify either an issue that's at the beginning of the technical dispute. That is, we started from the premise that, you know, the engineering studies had to say a certain thing and that didn't happen. And so that's where the disagreement is. But if you look at all the steps that were taken after that, everything else that was done, then, you know, there is no disagreement between the experts. I think that's tremendously helpful to tribunals if it's possible for experts to do that. As I said, we don't necessarily, it's not necessarily a good thing if experts are acting as advocates, because oftentimes that involves taking a view, frankly, of facts that I don't think is a role, or alternative facts. That's not necessarily the role of an expert. Obviously, you're going to be presenting one side's case, but again, you know, the expert is not the lawyer, and I think it's best if the expert is not, before a tribunal, is not tainted, if I can use that word, by expressing views that are really legal or argumentative views, and we may get into that more as we go along. But having said that, also, you know, a key element of being sort of an aid or of assistance to the tribunal also is being open to change, as I said, and being open to tribunals when they push for a better understanding or for some compromise in the way an opinion is presented. You know, I think there's nothing worse than an uncompromising expert that is essentially frustrating a tribunal because they won't give in and admit that certain things may also be possible. And so I think, you know, that those are the key things. You know, experts can certainly help the tribunal in understanding, and that's why they're there, because if we didn't need the expertise to help the tribunal resolve the dispute, then, you know, the lawyers could just argue all day about their own interpretation. So definitely a key role in that sense. I'll stop there.
Very broad and accurate view of the expert role. Alejandro, completing the lawyer view, what would you add or comment about the expectations from the expert?
Yeah. Thank you very much. Thank you, Luiz Fernando, and thanks, of course, to the organization. I want to join and to also reiterate Mélida's words and thank the organization, thank Lauro and João Bosco for inviting us to be here today. Of course, it is not the same to be in that conference, in my case, in cold Paris, and actually in confinement, than being, you know, enjoying Rio and enjoying, you know, having dinner with other colleagues and perhaps a caipirinha after the conference ends. We are definitely forward to doing that the next time in that city, in that great city that I love very much, which is Rio. But nevertheless, this time I think we will have to concentrate on the academic part of the event only, and you know, perhaps we'll drink a glass of wine instead of the caipirinha tonight. So. I think Mélida has covered most of the issues of what both counsel and arbitrators may expect or may need from the expert. I would like to add a couple of comments, not very much. First of all, I think it's important to differentiate between the process prior to the arbitration. And Mélida has referred to actually having the clarity, having the straight answer. I would even talk about that the expert, it is very useful to have a reality check of our case. And it is often the case where we have a client who is very eager and who actually is absolutely convinced that he has a winning case, that the other party is not right in respect of any of the points, of any of the arguments, and wants to start arbitration, you know, right away, convinced that he's going to win all claims and it's going to be, you know, an easy battle, an easy, actually, parade. That is not often the case, and we want an expert, or I expect an expert to be able to give me the technical arguments, to go back to my client and say, well, you know, case is good, but we need to consider this point and that point. Perhaps you need to reorganize certain ideas. Perhaps we need to do some more work here or some more work there in order to be ready for the battle. That is, of course, when you have the benefit of the early engagement of an expert. And this is something that I always emphasize to the clients. Okay, you are in a situation that may end up in a dispute, so let's involve an expert as soon as possible. Sometimes you are not in that situation. Sometimes you are representing a respondent that has been, you know, brought to a dispute in a more or less unexpected way. But generally in construction, that is not that often the case. Parties feel that the dispute is growing. So involving an expert early maybe always wise, and you know, it is a decision that at the end pays off. And what happens if the expert in that reality check process tells you, well, I'm sorry, you don't have a case, your case is weak, then you need to consider what, do I change my case? Do I change my strategy? Do I change and drop it altogether? Do I change the expert? and sometimes perhaps a client insists very much, and then you need to find a completely different approach, and that sometimes may require changing the expert, looking for a different scope, perhaps someone more creative than the expert you engaged the first time. Once you get into the proceedings, I definitely agree with Mélida in respect of we need this technical background, this technical knowledge to be able to convey our case to the tribunal, because even the most experienced tribunal, we need an opinion of an expert to actually be able to decide certain issues, particularly in the context of construction disputes. But in addition to that, I will also refer to other virtues or other characteristics I look in an expert, in particular in respect of these disputes. First of all, I will refer to the capacity to process documentary evidence. Construction disputes tend to be pretty intensive in terms of documents, not just correspondence, but minutes of meeting and complex technical documents. And I expect the expert to be able to process all of that, sometimes just to be able to convey that information to the tribunal in a way that the tribunal can digest. Not just because of lack of technical knowledge. We have very experienced tribunals who can actually get very deep into the merits of disputes, but actually who will need help to actually manage an enormous amount of documents and of data, and the tribunal perhaps may not have the time to do the process themselves. So the help, the assistance of the expert in that context is very important. I would also refer to the capacity of conveying a message, and definitely communication skills, credibility. And I think one of the points that Mélida mentioned was the difficult role when we have an uncompromising expert. I think it is important for an expert to say credibility, to be ready to concede a point, to give a point to the other part, to accept at the hearing or prior to the hearing. And I think that gives the tribunal the feeling that they can trust that expert. And I think it is important that our expert, the expert we choose for the case, is the one who is going to be trusted by the tribunal. And of course, the last point I would mention is experience. I want my expert to be seen by the tribunal as someone who is not just only knows what he or she is talking about, but actually, as a point of reference, as a safe haven, but for the tribunal. The tribunal can go there and can ask specific questions and will receive an answer that is not just based on technical knowledge, but also on experience. An expert who has seen this before or similar this before. And I think we will later go more deeply into the role of the experience of the experts. So then I will stop here and we'll let the panel continue. Thank you.
I think I wanted to continue hearing you and Mélida, because you are very good at the starting point. Now let's hear the expert view. Simon, present any explanation based on his or her experience or best practice in the market that could help a contract clause interpretation, to help the tribunal in the interpretation, not related only to legal aspects. What do you think about it?
Good morning, everybody, and I'd just like to thank the organisers for inviting me to speak on this panel. It's greatly appreciated. Hope everybody's staying well. It's a shame that I'm sat in my dining room and not on the beach in Rio, but that's life at the moment. Hopefully in May next year, I'll be able to be there in person. But thanks for the question. The previous comments were really good and kind of hit home as somebody who acts as an expert witness. But with regard to one of the comments earlier about bridging the gap between lawyers and experts, I personally still think an expert needs to maintain their own area of expertise and not step into legal interpretations of contract clauses, etc. It's important, from my perspective as a quantity surveyor, to have an interpretation and an understanding of contracts and contract clauses. And my interpretation as a quantity surveyor from a commercial perspective of a contract clause may differ from what the legal interpretation is of a particular clause. And I appreciate that a lot of expert witnesses are dual qualified as lawyers, etc. But if you're engaged as an expert witness, I think you really need to kind of, for want of a better phrase, stay in your lane and testify and give evidence based on your own professional expertise and experience. And on that point, there are, as a quantity surveyor, there are a number of guidelines. There's a particularly good one, I think, from the Royal Institute of Chartered Surveyors that gives you a guideline for surveyors acting as an expert witness. And that kind of differentiates that an expert witness does really stay in their lane and testify to the issues that they're experienced with. So quantity surveyors may have a different interpretation of contract clauses than lawyers, because quantity surveyors are not up to date with the law. And some of the clauses that a quantity surveyor would give an opinion on would be in relation to the payment provisions, for example, of a contract. Basically, the clauses that affect time and money from my perspective. So there's often discrepancies between an understanding between experts. You know, one expert may have one opinion as to how things should be calculated, and another expert may have another. If you're testifying in an arbitration and two experts that are equally qualified have a different interpretation of the contract, that for me is something that should be kind of thrashed out before you get into the, you know, in front of the arbitration tribunal. A common area of misunderstanding is unforeseen ground conditions, for example, on a project. I always try and differentiate that. Well, is it unforeseen or is it unforeseeable? I think there's a difference between the two. Unforeseen could mean that, well, you had the opportunity to investigate the site and you didn't take that opportunity. So therefore, that you as the contractor, that's your responsibility. Unforeseeable could mean that the project is in a ridiculously remote area, heavily vegetated, and it's not possible for you to investigate the site properly. Unforeseen ground conditions are a huge cause of disputes on projects, and particularly in Brazil, projects up in the Amazon, etc., where you're in a heavily vegetated area and you're building a hydropower plant. The unforeseen ground conditions can cause significant delays and additional cost to the project. So often in contract clauses, you will see that it's the contractor who has the responsibility to investigate the site. But if you've not got the opportunity to, or you've used your best endeavours, then who should really bear the cost for that issue? So that's just an example of how quantity surveyors may give a commercial interpretation as to what the meaning of a contract clause is. From my perspective, if I'm acting for a contractor as an expert witness, I would portray that the ground conditions were unforeseeable, if possible, and if they really were, and that the contractor is entitled to some of the additional costs and entitled to compensation for delay, etc. So it's quite an unclear kind of area that the expert witnesses venture into, and this is why discovery and working with the legal team is important, because like I say, a expert witness may have a different interpretation as to the meaning of a contract clause than a lawyer. So I hope that clarifies an unclear issue, in my opinion.
anything about it? About the expert explanation, or we can move on?
I think, Mélida, go ahead.
Yeah, I mean, I guess I would say I totally agree with Simon in the sense that you would expect that an expert has a professional or commercial, I believe is the word to use, understanding of contract clauses. Yes, we're not looking for legal opinions in the sense of legal conclusions, because a legal conclusion is going to determine the outcome of the case. But you have to have an understanding. The contracts are written around the technical project, and so you have to have an understanding. And I think you clarify that. It's very frustrating when experts, although their reports are, read as if they're written by counsel, then get to a hearing on cross, will say, well, I can't give an opinion on that because, I'm not a lawyer. So I think clearly they have some understanding of the way to read some of these clauses.
Yeah, I think I've been asked when being cross-examined, what is your interpretation of this clause? And I will always caveat that with, well, my commercial opinion as a quantity surveyor is the following, because I think it's really important that as an expert witness, you don't kind of put steps into the legal shoes for a couple of reasons. One, I'm not qualified to do so, and two, you're then giving a false impression that you're qualified to give a legal opinion, and in my opinion, you're not.
Yeah, that's the point I really wanted to touch. It's to be interpreted like someone who's trying to give a legal opinion, and it's not the aim of the expert. So, starting now with technical issues specifically. Alejandro, how could the expert help the tribunal or the parties with the risk allocation? Could the expert bring his or her experience, or just talk about the construction practices, about the shared risks, the allocation of risks, and specifically with the a situation that happened and is being discussed in the dispute? How could the expert help the tribunal and the lawyers? Not here.
You are on mute, yes.
Yeah, that's fine now. So yes, thank you, Luiz Fernando. Actually, this question is very much linked to the previous one. So that's why I before I hesitated a little bit in dealing with it as a comment to Simon, or just waiting and discuss a couple of additional points, because the issue of the interrelation between the legal issue and the technical issues is always quite complex to address. And I totally agree with Simon's comment in respect of the idea that the expert should not be the one entering and discussing the legal aspects of the case. And as a rule, in principle, the expert should stay away from legal issues. They are, in principle, not expected to interpret contracts, and as Simon said, and also Mélida commented, this is an area of danger, and we want to avoid that the expert is opening himself or herself to questions about contract interpretation. So, in principle, in that respect, the expert should rely on the instructions from counsel. That is, what the book says. We are playing by the book. As experts should look at counsel and say, well, give me instructions in respect of how do I interpret this or that, and from that point of view, from that instruction, I will build on my technical knowledge. Okay. This is, as I said, the standard approach, a bit of the rule by default, but is it always so? Is that always the case? And I don't think so. I think the experts may interact very much in interpreting contracts, and actually, in some occasions, you actually need an expert to make sense of a contract simply because the parties have decided to introduce in the contract terms which have a technical content, which have a technical meaning, which only can have a technical meaning. And also, I would like to go and refer, for instance, to what appears in Article 21.2 of the ICC rules, when it refers to the fact that the arbitral tribunal is not only obliged to take into account in deciding the dispute the law applicable to the contract, but also any relevant trade usages. And I think in that respect, an expert can be helpful to bring to the tribunal the content of a trade usage in a particular area. And trade usages may differ very much, and that may be a very broad concept, and sometimes we lawyers don't pay enough attention to that. But having someone with experience in the field, being able to explain to the tribunal how things are normally done in a certain industry, how this type of project is normally built, and why what the parties in the case departed from that common practice is also relevant. But we have sometimes contracts which actually oblige a party to comply with a certain standard, for instance, to build something in accordance with good industry practice. So we definitely need an expert. You will definitely need an expert to define what is good industry practice, or to provide some equipment or some machinery which is in accordance with the state of the art. Those terms, which are seen often in contracts, need the interpretation of the experts. And I was recently in a situation where there was a dispute in respect of the automation of a renewable power plant, and the parties discussed whether the automation provided by the EPC contractor was in accordance with the state of the art or not. And given that renewable energies are changing, are developing quite rapidly, the question became really important in order to be able to interpret the contract, to interpret what was the meaning of that clause and whether a party was or not in breach of that contract. And the only way to do that is, with an expert who can explain what is in accordance with the state of the art, or whether one of the parties was requiring something that actually was not, was beyond the state of the art. Okay, so these are examples of that type of situations. In contracts for O&M, for operation and management, we may find duties for the owner to provide personnel of such caliber to actually operate and maintain a certain facility. Again, that type of clauses need interpretation, and in order to see if the problem, if the breaches associated, or if the damages which have occurred are, for instance, a result of the poor caliber of the personnel provided by the O&M company or by the owner, or are actually the issues are issues which may be attributable to failures in the design by the EPC contractor. So these are, as I said, examples in that respect. So going to the issue of risk allocations, well, allocating risks is definitely one of the main purposes of construction contracts, and we have classic risks such as weather, ground conditions, of course, Simon mentioned them before, changes of legislation, labor situations, increases of price of certain materials, etc. And in those cases, in some of those cases, you definitely need an expert who is capable of explaining the tribunal what is precisely the impact of that risk in the performance of the contract, what party may be better prepared to deal with such risk, how often do these risks materialize, or whether the occurrence of a risk is something normal, foreseeable, or it's something absolutely extraordinary that a diligent party, a diligent contractor could not foresee in that respect. And for instance, we may look at the ground conditions, which, as I said, is very classic type of risk allocated in the contracts. And in the NEC form of contracts, there is a risk-sharing principle. So clause 61.12 of the NEC form of contract provides, and I quote, that the discovery of physical conditions which an experienced contractor would have judged at the date of the contract had such a small chance of occurring that it could have been unreasonable to allow for them, that constitutes a compensation event. So what is the meaning of that standard? How are you supposed to interpret the standard, the foreseeability standard that is there required without having an expert who can explain, who can provide his or her view from the perspective of his or her experience? I think that is an area where expert opinion is critical. That can there are also other areas where actually economic experts can help the tribunal to understand the economic motivations of the parties, and one sometimes tend to think of economic experts as experts who can only, or who are mainly, the main purpose is to actually decide on quantum, decide on what is the consequence of the breach of a party. But economic experts, financial experts can have another role in actually trying to explain the economic reasonability of the distribution of certain risks, and actually, to rule out a certain interpretation of the contract because it doesn't make sense. It doesn't make sense in the scope, in the interaction between the parties, or can even help in understanding or analyzing the behavior of the parties, considering that parties have an economic motivation which is actually driving their decision-making progress. So I think I cover some of the points related to the risk allocation and risk sharing. Of course, this topic could be a topic for a conference in itself, but I would like to give the word to my other panelists.
Okay, thank you very much. Simon, would you like to add something in a commercial perspective or technical perspective about risk allocation? No sound. You are mute.
I apologize. Thanks for the points, Alejandro. Some really good points there that I'd like to address from a commercial perspective. Going back to basics, risk from a quantity surveyor or construction professional perspective is an event or a series of events that can negatively impact the plan of a project. But along with risk, I think comes opportunity as well. A situation that can favorably impact the original plan of a project. And the purpose of contract clauses is to address those areas of risk. And when you have contracts that are amended from standard forms, those amendments are usually made to distribute risk, sometimes unfairly. The common perception is that the owner will want to transfer risk to a contractor, the contractor will want to transfer that risk to a subcontractor, and so on. So you often have subcontractors that are taking on significant risk with low margins of profit, and it's just a breeding ground for disputes, in my opinion. So contract clauses and their interpretation have significant legal implications. Before any contractor signs a contract, subcontractor, contractor, they should really have those contracts reviewed legally, in my opinion. the common phrase is that construction is a risky business, and it truly is. That's why we're here now, and that's why there's so many people employed as construction lawyers, arbitration lawyers, and expert witnesses, etc. Because it's a breeding ground for disputes. It always has been, and I think it really always will be. There were a couple of points that Alejandro made about where the expert witness and the legal team do interact and work together without the expert becoming adversarial. Couple of examples would be if there's a question on whether the liquidated damages clause in the contract is enforceable, and legal counsel is arguing that the liquidated damages is a penalty. It's not really a fair assessment of what the loss would be. The expert not giving a legal opinion on that can assist legal counsel in calculating what the actual damages of the delays are, and therefore assist legal counsel with their argument that such a clause is unfair. Another issue is when there's a termination and legal counsel is arguing that the termination is unfair if it's for delay, for example. The delay expert can assist legal counsel in putting together an argument that the termination is unfair. The contractor's being blamed for all these delays, and as this delay analysis shows, the contractor was not responsible for all the delays, and in fact, the contractor is entitled to an extension of time. So, although the expert is assisting legal counsel, they are still remaining impartial. They're not giving a legal opinion, but that's an example. And I just wanted to raise that because Alejandro, you raised a good point early on, where you were talking about expert witnesses and legal counsel working together, and I think those are two pretty distinct examples of where that does happen. So, hope that's sufficient points. If anybody has any questions or wishes to discuss, I'm here.
Okay, let's go forward. And I would like to bring it to you a very rare situation that I faced once. That is the two different causes that can bring the same effect. I'm talking about the cost reduction effect that can be caused by a value engineering that is common in almost all the contracts. In the FIDIC model contract, we have the clause. And we have the risk allocation in the contractor that is due to the design development. If you have different stages in the design development, you have the basic design, and you develop the detailed design, and you have, mostly of times, you have a quantity variation. So, normally in the construction site, we don't have any doubt about if the cause is a value engineering or if it is a design development consequence. But in a dispute, we can face the situation that one party alleges it is a value engineering and the other party alleges it is a design development stage. So if we read the clause, it is focused on the cost reduction, just the effect, and doesn't try to find out what is the causation. So we can start with, I would like to hear one lawyer and Simon as an expert. How do you face this difficult situation? Could you start with you, Mélida, in a lawyer perspective?
Sure. I think it is a tough thing, and in my experience, what usually is the issue is more of a design problem or a change. Let's say not a problem, but a change in design. Now, of course, the reasons are why that is the case. One has to then go to whether or not there was an initial problem in the design, or if, as Simon mentioned in an earlier discussion, there are reasons related that are, were unforeseen or unforeseeable, when that too then determines who should bear the risk allocation for that. But I guess in my experience, I don't so much see an issue of there being cost reductions where you then try to determine whether or not that gets passed on from the contractor to the owner, but more issues where you have a change in design that then needs to be, the issue then becomes who bears the cost of that. So, for example, if you decide for whatever reason, maybe it's on a construction on a hill, or it's a building, and you were going to build 2 terraces or 4 terraces, 2 of which were going to actually be supportive terraces, and the decision comes that you're only going to build 2, 1 on each end as opposed to 2 and 2. Who bears the cost of that? Why is that? Is it that building into a mountainside, someone did not do the right survey in terms of the conditions, or is it because I think that's I'm not sure there is an or. I'm trying to think about the or, because the contractor will say, well, we couldn't see that, or actually it's not necessary to have 2 that are supporting. You only need 1 on one end and 1 on the other end. And so therefore it becomes, well, number one, was this what the parties bargained for? That's the legal way of looking at it. But then you have to understand the technical way of it also, and that's whether or not technically that's correct, the change is correct from a design perspective, whether or not it's actually feasible to change. And then you have to rebalance. So many of these are, for example, I shouldn't say so many are, but in a public construction project sense, you have, it's not just a commercial endeavor. You have funds that are public funds that are behind the project. And so you can't just change a design. You can't just change the design and decide that you don't get to pass on a savings that results from that change in design. Obviously, there is the issue again of whose fault is it that there's a change in design? Was there a condition that should have been known? Was there a condition that wasn't revealed and was known? But ultimately, particularly in public projects, there is that balance, or risk allocation that Alejandro spoke to, and therefore that, in my view, is often the subject of the controversy, is how that gets passed on, how the savings gets passed on, as opposed to whether or not there are additional cost increases and who should bear that. But I think more often we do see the issue of cost increases allegedly because the conditions that the contractor understood have changed and have required a change in design that now becomes more expensive. And the claim is that an increase in cost should be passed on to the consumer or the other contractor, in essence. And I think that's really, those are sort of the 2 primary debates that we tend to see. But I think particularly where design is concerned, I think we have a general understanding that the contractor has the expertise and therefore bears the burden or the risk allocation of design. And so whenever you have a change in that design, shifting the allocation of risk for that change becomes controversial, and I think ultimately is what leads to probably most disputes that we see.
Okay, Simon, considering that in an EPC contract, lump sum contract, the variation of quantities risk is allocated to the contractor, and you have always positive risks and negative risks, mostly negative risk. You have 9 out of 10 negative risks, 1 is positive. So the positive risk, the cost reduction in that one case will balance the other variations. So how could you explain that situation is explaining to a tribunal is related to a design development and not for a value engineering that considers other aspects like reduction of scope, reduction of quality, reduction, changing of solution, and so on? How could you deal with this situation?
Well, firstly, I think we should address that value engineering is often a part of the design development anyway, and the heavy risk is always with the designer, whether that designer is part of the contractor's team, if it's a EPC type contract, or if it's a third-party designer. That designer puts their name on a drawing and authorizes it that it's kind of good to go. And the purpose of design development and value engineering is to reduce the cost for the owner at the end of the day. And in reducing those costs, you still have to meet the intended outcome of the project, the specification. So I know, and I think why you raise this point, because this is often an issue on projects in Brazil that I've seen. So there are often, say for example, on a process facility, an offshore platform type facility, you've got limited space on that facility. You're given a concept design from an owner, and you're to develop that concept design as the EPC contractor. You come to a situation where during your design development, you realize that offshore platform doesn't have the space that was intended for particular equipment that forms part of this facility. So the result of that is you have to use additional structural steel off the side of these platforms to house a particular piece of equipment, pipe, conduit, etc., to try and meet the intended specification of the project. On some of the projects that I've seen in Brazil, the owner is of the opinion, well, this is your problem, EPC contractor. I give you a concept design. Your job is to go and detail that design, and you bear the risk for any anomalies in reaching that specification. Is that really fair? In my opinion, no, it isn't. You're given a concept design, and you're given a certain amount of space to develop that design. And the space you're given does not give you the functionality to meet the specification of the project. So there are often disputes that arise in those situations. And my general opinion is that, yes, it is a design build contract, but you've given us a specification, and the facility that you provided does not give us the opportunity to meet that specification. So that risk should go back to the owner. Does that answer the question?
Yes.
Okay.
It is the risk allocated to the contractor. In this case, should be borne by the owner, the employer.
Yeah, that's not in every case, but I just gave an example, I think, of where that risk should go back to the owner, generally speaking.
Yeah, I think this analysis is important to help the tribunal to understand the situation and to have a good decision. Is this something that must be supported by the employer? Is this a risk allocated to contractor? So he has to bear the negative variations and to support also the positive variation, and try to difference, like you said, the variation is a value engineering situation or not, it's a design development situation. I think it is important to help tribunal to find the precise cause of the variation. And then they naturally you decide and have a good decision.
Yeah. One possible way to alleviate those issues are if there is like a pain and gain share clause in the contract, so cost savings are shared and also the pain is shared. That would put more of an onus on the owner to get rid of the mindset that once I issue a design and build contract, that's it, I have no more responsibility.
Okay, thank you. Let's try to move now to let's discuss the evidence expectations. We here in Brazil face a very hard situation that the evidence, the tribunal has an expectation. They often want a deeper investigation and an impartial opinion. And the lawyers, the party counsels perspective, they want the expert to prove their theory. So many of evidences that the experts try to fulfill the party expectation doesn't help the tribunal. How do you see this difference in expectations? Mélida, could I start with you?
Sure, and I think, you know, this is a problem or an issue for just about every tribunal, not only in the technical sphere, but certainly, I think in my experience, I've seen it more when looking at the issues that come up with damages, economic damages, for example. So I will start by saying that I think I see the issue less in dealing with technical expertise as opposed to economic expertise. And I'm also of the view that perhaps there needs to be, frankly, stronger qualification of experts and the kind of expertise that they're presenting. You know, and not to borrow necessarily from the US, but there is a sort of process that we go through in US courts that's called the Daubert process. And that essentially requires the qualification of experts and the kind of expertise that they're going to give, and qualification in the sense of establishing the scientific basis for the kind of evidence that is going to be presented to a court. Obviously, one reason for this is that you tend to have juries in most US cases, judicial cases. Whereas when you're dealing with an arbitration tribunal, obviously the idea is that you've chosen arbitrators who have a certain level of expertise, and therefore you don't need to protect them from sort of voodoo economics or theories like that. But I frankly think that it could be good to have a system where you force experts to really justify the technical basis, the best practices, the whatever industry guides there are, to establish the reasoning behind their expertise by presenting something that says, this is not just a crazy idea that I've come up with. Again, I think it's easier in the technical arena because you do have industry best practices. You do have guides that are established by through collaboration between technical experts, and frankly also I think you don't have experts who have been developed or who haven't established their careers on the basis of the opportunity to testify in an arbitration tribunal. You know, they're experts who work collaboratively with each other in order to develop the best practices, the best industry practices. No one wants to go into a project thinking that, you know, well, I'll half design it or not design it properly, and, you know, we'll deal with it in litigation. No, I do think that there is a certain level, or I assume that, you know, the experts who are coming into to testify in an arbitration are strictly that. They're technical experts who happen to be testifying in an arbitration, and they're not dedicated to working, for example, with particular firms that specialize in certain kinds of disputes and therefore reappear all the time as experts on a particular topic, whether it be changing the design risk in engineering studies and who should bear that, or whether it be earthquake, building for earthquake, different scenarios of earthquakes, 1,000-year, the 500-year, the 100-year. I do think that we see less of that in the tech when we're dealing with technical experts, but I could be wrong on that, I will admit, but I tend to see less of the same exact repeat players. Nonetheless, with that caveat, I do think that when you have less than ideal presentations or explanations to a tribunal, then, you know, that it has an impact. And I think I've said this before also, is that because the technical damages or the technical issues and disputes are so relevant to developing and establishing what ultimately damages may be, or whether or not there should be damages, then it's important to have technical opinions that are less subjective, that are more industry-based, more scientific-based, and I think that this is one area where, you know, it's tribunals are looking for clarity, as I said before, also in my view, and you need to be able to present it in a way that is not going to seem that you're just a hired gun, and I think most technical experts approach it that way. I do sometimes see experts who, for whatever reason, either because it's easy or because they've perhaps worked with some counsel on a lot of different disputes, end up having a narrow view of the way things should be. But I do think generally the evidence that is presented on the technical side tends to be more straightforward, tends to be aimed at being able to have the tribunal understand what the actual technical nature of the dispute is, and whether or not, therefore, you should readjust the risk allocation and essentially reassign costs for or within the project. And this is, I think, important also because in my experience, oftentimes you're dealing with a project that is still continuing. The parties still have to deal with each other. And oftentimes in contracts, you will have provisions that say, whatever the determination is of a particular dispute, goes on to form part of the contract. And so if a tribunal says, you know, this change in design changed the balance of the risk allocation, and that change in design affects the next 30 steps in the construction, obviously it has a huge impact. And for that reason, you need to have technical expertise, again, that is certainly impartial, but as best founded as possible in what true and in truly sort of industry standards, and not based on perhaps what an expert may want it to be, or what I should say the expert's client or counsel may want it to be. And so it may be that on a technical level, there needs to be, and this is, I don't think this requires a great change in the way we do things, but I do think it's the tribunal's responsibility to ensure that the kind of evidence that is presented is scientifically sound, technically sound, industry sound, in order to ensure that the decisions that are going to be subsequently made, particularly where it affects not only an allocation of damages ultimately, but frankly, the way a project is continued to be developed, it's important, I think, to have that kind of evidence be on the strongest, firmest grounds possible.
Mélida, as you said before, as you mentioned, it is important that the expert is open to change opinion during the discussions. And mostly, it's very important to be impartial, to have an impartial behavior. So it could be addressed by the tribunal. And one other thing that I think is important, many times you have different calculations because the experts start from a different premise. Could the tribunal address that premise and that their expectation before producing the evidence?
Let me unmute. Yes, certainly. I think that's possible. You know, if you're in, I guess, the ICC world, then you know that's the kind of thing that could be addressed. For example, in a terms of reference, sort of what are we actually going to be looking at very specifically. I think what happens is it's difficult to do that because the terms of reference happens so soon in a proceeding, even if, as Alejandro mentioned, you know, the dispute has been building. You know, the parties know what the dispute is. They know that the dispute is over, you know, the engineering study number 2 that says, no, we're going to change the type of drill that we said we would use in our bid, and we're going to use this one. Don't worry, it's the same thing. It will be as fast as the other one, and there develops a dispute either because you have experience with the new drill and it's not as fast, or because quite simply the other side just doesn't trust that or says, okay, fine, but then let's reduce the contract amount. And so those are the kinds of things that it helps to define, I think, early on exactly what the 5-6 points are. And I will say one reason why this helps is because it's better to resolve that or to understand what the specific points of dispute are that are going to ultimately resolve the claims than to find out, for example, at a hearing or after a hearing that a tribunal now needs more evidence, something that I see happen all too frequently. Because it's only after that late in the game merits hearing, perhaps, that the issues have crystallized and for the tribunal. And so I think that tribunals perhaps need to think more about the flexibility that's afforded to them to conduct the proceedings. Many arbitration rules will very bluntly or clearly, I guess might be a better word to use, state that you know, the tribunal is in control of the proceedings and of the conduct of the proceedings. And perhaps it would behoove tribunals to think about defining or narrowing the issues that are really going to determine the resolution of the dispute early on. And so if it's not possible to do that in an ICC terms of reference that comes at a relatively early stage, then maybe it's possible to do it nonetheless later on, and to sit the parties down, perhaps after a first round of pleadings, and say, we would like to understand these particular issues. We've read your pleadings. Now we've read a round of pleadings. We want to understand these particular issues. Please address these in your next round of pleadings. I think also there's been some discussion, I think it was proposed by Mr. Kaplan, about something called a Kaplan hearing, which sort of has earlier hearings to resolve particular issues in disputes, and therefore narrow what the ultimate issues are. And I think it makes sense. If you think about, you are going along, you start with a universe of issues or claims that may have various underlying differences in understanding or in interpretation of the contract, in essence, and the way the design was going to develop, for example. But that design, from the contractor's point of view, may need to develop, and as Simon mentioned a few minutes ago, may need to develop differently, because the conditions that were understood by the contractor when they presented the design are different. And so it is a live thing that needs to be adjusted, and I think tribunals will do everybody service if they can say at certain points, okay, we've read, we understand what these issues are, and before we spend a year and a half with pleadings sort of talking past each other as they often do, here's what we understand the issues to be, and let's resolve these particular issues now so that we can then move on to resolve ultimately the big issue, which is going to be, most likely who has to pay for it. But if you can get that sort of understanding early on, I think it would help a lot to resolve disputes. So I think things like terms of reference, or just periodic sort of tribunal check-ins to address certain specific issues would help. Now, the problem with that is, we're all designating tribunals on the basis of years and years of expertise. And oftentimes those people with years and years of expertise are not available to have that kind of a hands-on management of a case. And so that, we all ask, is someone available to manage a dispute when we designate them? But the reality is that oftentimes, as we know, you go to set the procedural calendar and everything is 2 years out or more, and there is no provision for going back to the tribunal, or for the tribunal to essentially affirmatively intervene and say, okay, at stage one, we're going to look at this and look at these particular issues to resolve. And then depending on how that's done in the next set of pleadings, we will then resolve even further whether or not, we're closer to having a hearing that perhaps a final merits hearing that's perhaps, only 10 days instead of 20, or only 5 days instead of 10, because you've worked along that way. But I think given the current structure of our arbitration system, where there really is no intermediate discussion of the issues, or very rarely, that's difficult to do.
Okay, thank you. Considering that this is an important issue, feel free, Alejandro and Simon, to bring your concerns and considerations about the tribunal orientation, the term of reference. What do you think about it?
Thank you. Well, I think the points raised by Mélida are perhaps amongst the hottest points, or the points of discussions. There is this dilemma, which seems to be an inherent contradiction in the system. So we all agree. We all agree with the theory. Experts have to be independent, have to be impartial. They indeed are. They have an overriding duty to the tribunal. they have to take, taking Mélida's words, the scientific approach, and hopefully experts will not be hired guns, but actually, you know, will assist the tribunal in a neutral way. But and I'm going to try to be a bit provocative in this extent. So what is the reality? Has anyone seen an expert, a party filing a report, a party filing a submission with an expert report which does not support its case point by point? I haven't. I normally find that experts from, you know, very reputable expert firms and lawyers from very reputable expert firms submit reports that support integrally each party's case. And it's difficult to understand that if both parties have followed precisely these rules of being independent, impartial, of following scientific approach, etc., how that situation, how that outcome is possible. And actually, you know, throwing the question to lawyers here and at the audience, would you as counsel submit an expert report that actually, you know, criticizes your case or that damages your case? I guess you will not. So I think that the initial approach is that counsels, we expect the expert to be able to support our theory of the case. And actually the first, let's say, deviation, if you allow me, and as I say, I'm trying to be a bit provocative from this point from this purpose of finding a solution which helps the tribunal to find the truth, is perhaps that the counsel draft the instructions to the expert. So the counsel you know, in this interest of defending of supporting the theory of the case, is putting some premises upon which the expert is going to build his or her work, and that, of course, sometimes depart from that idea of finding the absolute clarity which will help the tribunal. And the expert and counsel will often work alongside to make sure that, you know, weaknesses of one's case are not going to be denied, but we're trying to, they will try to make them to go as unnoticed as possible, and that the report is structured in a way that, you know, puts the emphasis on the points that benefit that party. So this does not mean that the expert is going to accept everything that the clients request. In my experience, experts normally do not lie. I have seen, of course, exceptions, always the opposing side, but I have seen, of course, exceptions of experts, you know, blatantly lying. But often the difference is a bit more subtle. So it is in the way premises are selected. It is in the way, the scenario upon which the expert is going to put the emphasis that actually make sure that the spotlight is in one part of the analysis and not on the other. And there is an art to this. There is an art to this, of doing it in a consistent way, you know, falling within this scientific approach. And of course, experts do often tell you, well, I cannot state this. I cannot support this argument that your client wants me to make. I don't feel comfortable going as far as that. And I think that means that you have the right experts. So because there are limits, and you have to live within those. But at the end of the day, what we find is that in practice, both parties use these elements of, you know, choosing premises, choosing scenarios, or putting more emphasis here or there to actually make that the report is supportive of one case and not supportive of the other. So from the arbitrator's perspective, that there lies the challenge, because they need to actually get in depth into the reports, and they must read the reports from the experts very carefully. And an arbitrator shouldn't only concentrate on what the expert says in the report. Perhaps sometimes it's more important to understand what the expert does not say in the report and consider why the expert decides not to deal with a certain issue, or to deal only in a very light way, because there may be, the weakness of the parties of one side, or an element, an argument that somehow the counsel instructed the expert not to deal with because he knows or she knows that would damage its client's case. So that careful reading, careful analysis of the case is definitely very, very important. And in that respect, the experience that the arbitrators have in respect, generally as arbitrators, but also the experience they have in respect of the subject matter of the dispute, in this case, construction, maybe infrastructure, maybe energy, etc., that is critical, because that will, as I said at the beginning, this experience of the arbitrators will not allow to replace the expert, but will allow the arbitrator to understand what is wrong with an analysis of an expert, or why the analysis of another expert is more consistent, or is right, or actually touches upon the critical issues. And a final comment, if I may, is also that what can be expected from an expert is different if one relies on an habitual expert, meaning an expert who is not only expert in its field, but also is used to the forensic litigation, to actually presenting cases in front of the tribunal, and has also these soft skills of being able to convey the message and understanding what this game of arbitration is about. But oftentimes, you need to find an expert on a very specific topic, and then you need to rely on a university professor or on a consultant, because there is no one else in the field being able to explain something on a very specific issue of resistance of a certain material, or a specific technology that is new, that is being developed. In those cases, the work for counsel becomes even more difficult to make sure that the expert delivers what the expert, what the counsel expects from the expert. Sometimes these experts have difficulties to understand precisely what the role is, what their duty is to the tribunal. Sometimes it is difficult for those experts to understand exactly what is the expert report, and they need assistance in actually drafting it, in understanding the format, in understanding the questions, in understanding the evidence that needs to support. For instance, you need to you need to introduce footnotes, you need to annex every document you mention. That type of things may be critical for the credibility of a report, and actually for the tribunal to assess it. And also, it is difficult for counsel to control those experts at the hearing, because they sometimes believe more in the world of ideas, or in the world of technicalities, and maybe expansive when they talk about their own topics. So these are challenges that these non-habitual experts pose to counsel, to lawyers, and also to arbitrators. And a critical point, and I think we will mention that later again if we have the time, is that the counsel love to have control of the case, of the litigation, and actually, freak out a little bit when they lose control of the case in the middle of the hearing. And that may happen with one of these non-habitual experts.
Okay, thank you. We have started discussing the hearings. Simon, would you like to add anything about the term of reference, or can we go through the hearings and the evidence protection?
Yeah, I just have a couple of points. Nope. Some very good points raised, and Alejandro, one of the points you raise is about control of the expert, and the expert supporting the legal position. And I think that hits home with one of the points you raised earlier in the discussion about engaging an expert early on. I think it's important that an expert is engaged early on in the process, not right at the end. I think the expert's evidence and the expert opinion should be perhaps part of your legal brief, but your legal brief and your legal mandate should not influence the expert's opinion. So I think you can take the expert's opinion and incorporate parts of that to support your legal theories and your positions, but the expert still has to remain impartial. So you can take the expert's evidence and as an advocate, present the positives of that case in any way you see fit. But the expert's opinion should not be altered to match your legal theories, because there's already an inherent kind of perception that because the expert is hired by one firm and the fees are paid by that firm, that they're going to side with those positions. So there's perhaps already a barrier for the expert to jump to establish to the tribunal that although I'm being paid by a third party, my duty is to you, the tribunal, to give you my independent opinion. And there are a number of mandates on that. In particular, as a quantity surveyor and a member of the RICS, there are duties as an expert witness, and those duties are to the tribunal and not to your party or to your legal counsel. So to sum that up, as an expert, your credibility is everything. And the moment that credibility starts to diminish, your case starts to fall apart. And it should always be in counsel's mind that that is the case as well. Just to sum that up.
If I can jump in there, because I am going to push back against Alejandro in that sense. I mean, I've had experience with having, you know, and it is perhaps the expert that is not the repeat expert with or repeat with particular firms expert, where on very specific technical issues, you know, that I'd not heard anything about before, you know, you search, you find these experts. And I found a couple of experts who had only testified, for example, in US courts, had not testified in arbitration. And so we're used to essentially being tested before even being able to present a point of view. You know, in looking at one of the issues, one of the construction design issues, said basically, your client is half right. You know, there's one issue where you can interpret it that the design, the change that the contractor wanted to make is allowable, is correct. To the letter of the law, that is a letter of the manual that they're following, it's correct. Is it best practices? Not necessarily. And so, you know, how do you want us to present this? Present it the way it is. That is, it's your independent opinion that says it's not exactly correct. However, we understand why your client would have thought this because it's not best practices. So it does allow some, but I am personally a lawyer who feels it's best to, again, maintain the credibility with the tribunal. I want to be the side or the party that the tribunal, if it has doubts, gives the benefit of the doubt on credibility than the other side. And therefore, I think you gain intangible points with that. And in that case, you actually gain very tangible points, because it's important, I think, to be honest with the tribunal, even when it's a point that is not necessarily going to go for you. So I just wanted to push back a little bit on that.
Yeah, no, Mélida, just for the sake of clarification, I agree with these points. I was, you know, trying to be provocative, but at the same time, I have to see that in my experience, when I see the reports coming from the other side, I not very often see that type of approach, that the report coming from the other side actually acknowledges the shortfalls of the other party. So that means that every time I have litigated, I was against a party who was absolutely right, and then my client was wrong, or that is something that doesn't, you know, not everyone follows that approach, and that is a concern for everyone, of course, for the experts, because the credibility is the most important asset that they have, and I totally agree, but also for the tribunal who has to decide, and sometimes they cannot trust an expert or both experts, depending on these type of tactics. And definitely, I want to have on my side the expert who can be trusted by the tribunal, because it comes across as being clear, as saying the truth, and offering a full picture of the matter.
Okay, thank you very much. Very good session. I think we have a last issue, a last point. We have more 5 or 10 minutes. And then I would like to hear from you. What do you think about the tribunal asking the expert to meet themselves and to try to find common grounds? What do you think about the hot tubbing in the hearings? What, in your opinion, is the best practice that can help the tribunal and to help to produce a good evidence? Let's start. Alejandro, can you start?
Yes, of course, and I think we already touched upon this point in respect of the previous topic. They are very closely related. So, in the interest of time, I will try to be brief and deal with a few points here. And actually, following with these difficulties a tribunal may have in actually making the approach followed by both experts compatible. One of the tools that tribunal have is to ask experts to liaise early in the proceedings, because, as I said, sometimes tribunals have a hard time navigating expert reports simply because they do not deal with the same things. So it's not that an expert says A and the other one says no, A is not true, it is B. It's sometimes one talks about A and the other ones talk about cases 1, 2, 3, and 4. And then the expert the tribunal doesn't really know how A fits into these 4 cases, which refer to different type of situations, and they depart from different premises, or they answer different questions. Sometimes that's intended. Counsel do not want the cases to be comparable because they know the counsel on one side, or perhaps in both sides, because they know that in a direct confrontation they will lose, all the weaknesses of one party's case will be discovered. So we, using this old expression, expert reports are like ships crossing in the night. As I said, because sometimes just parties want to have the debate in these terms. So more and more often we see tribunals to rely on that tool to actually, exert this control that the proceedings give the experts, to which Mélida referred earlier, to actually, grab the expert and say, hey, come here, let's do this thing in this way. And experts may instruct the tribunal may instruct the experts to actually meet early in the proceedings, sit together, ideally try to narrow down the points in dispute. But if they can't, at least to make sure that the experts opine on the same topics, and to make sure that they use the same premises, factual premises, technical premises. They use, I don't know, even the same metric system, use the same elements, the same methodology, or explain why there is a difference in methodology, and therefore that difference in methodology becomes an apparent point in dispute that the tribunal will need to address. That, of course, makes the life of the tribunal much easier, and also, in an ideal world, gives certainty to all the parties involved. So I see the trend of tribunals asking for these meetings of experts happening as early as possible, even sometimes shortly after the constitution of the tribunal, perhaps ordering or instructing one meeting between the experts to take place even before the parties have submitted the first round submissions, just to try to make them to know each other, trying to build some trust between them. And I think that is an interesting approach. In that respect, I would like to mention the Charter Institute of Arbitration Protocol for the use of party-appointed experts in international arbitration. In its Article 7.2 provides precisely that the arbitral tribunal may at any up or during the hearing, so before the hearing or during the hearing, direct the experts to confer further and provide further written reports to the arbitral tribunal, either jointly or separately. And there is a second clause, 7.3, which talks about the holding of preliminary meetings with the experts by the tribunal, and that is more the idea of the Kaplan hearing that also Mélida touched upon earlier. So these are two different mechanisms. These experts conferring on their own to provide joint or separate reports before the hearing, on these meetings between the experts and the tribunal. So these are tools that the tribunal have to actually try to focus the debate on the experts and make that debate more useful for the tribunal. So a number of questions arise from these meetings, and I'm talking about now the meetings between experts from each side, without the presence of the arbitral tribunal. And the first question is, what is the role of counsel in these meetings? Do counsel have any role at all? Are they allowed to participate in those meetings or not? Can experts revert to counsel after the meetings and discuss how the conversations are developing, or can't they do that and they have to wait until they reach a conclusion or not? Can an expert stop the meeting in the middle and say, hey, I need to consult with a party before taking a position in this point or in that point? Of course, perhaps that may not be the most advisable from the perspective of the credibility of the expert, but what if that happened? We need to keep in mind that while experts do not represent the parties and therefore they cannot settle the matter, if they agree or they don't agree on a certain point, that may be critical for the case. And this is, of course, related to what I referred to earlier about counsel's panic to lose control of the case. So having control of the case doesn't mean being able to influence on the outcome of the case, but actually at least to understand what is going on, what is happening, etc. So these are, I think, questions which are relevant and that we counsel need to make sure that we have an expert, that we engage an expert which we can trust, and I use trust in the sense of making sure that we know that the expert knows the case well, knows the evidence well, and knows the technical aspects of the case well, so that expert can be on its own in these meetings and expose and defend the arguments and points that the expert is making. Another relevant point or relevant question is, are these meetings without prejudice meetings? In other words, and this is a discussion every time that there are meetings of this type, in other words, can the content of the discussions between the experts be used at the hearing, or only the resulting product signed by both experts from both sides can be discussed at the hearing? So if an expert starts by defending a position and after a while changes position, for instance, an expert in these discussions starts by conceding one point, but after, I don't know, having a phone call with counsel, changes opinion, that early concession can be used, can be reported to the tribunal, or cannot. And only, as I said, the final product of these meetings is allowed to reach to be sent, to be presented to the tribunal. And what is the outcome? What is the form of the outcome of those meetings? Well, the Charter Institute of Arbitration Protocols talks about a joint report. That may be an ideal outcome, but I think in occasions that is not practical, that is not realistic. It is difficult to expect that different sets of experts are going to sit down together and draft a report as such. What I see more often is is either that they issue separate reports, but with common questions, or they answer common questions and they accept common premises, and then on the basis of that, their next report is drafted independently, but at least there is a commonality on respect of the points that they are addressing. Or I have seen the use of the Scott schedules, so essentially a big chart where the experts agree on questions and they express if they are in agreement or if they are in disagreement, and the reason why they are in disagreement, if this is depending on different methodology, different facts, different data, etc. So I think all in all, this is a good tool. I have used, or I have seen that this tool being used in an efficient manner by tribunals, and result definitely on the narrowing, perhaps not so much of the disputes, but at least on identifying what are the real disputes and what are the elements that the tribunal needs to decide to efficiently deal with the points of dispute. And I think I will stop here. I think there was a second part of the questions about hot tubbing, but perhaps Simon, who will have suffered and enjoying the pleasures of these hot tubs, perhaps can address that better. Thank you.
Simon, I think we have 1 or 2 minutes for you. Please bring your considerations, final considerations, please.
Okay, so on the point of hot tubbing, I think it's a really useful tool in arbitration, and in my experience, it usually occurs at the end of the hearing, and it gives the tribunal, in my opinion, an opportunity to seek any clarifications on issues that may remain unclear to the tribunal. One of the concerns I would have with hot tubbing is that the arbitration tribunal must maintain control of the hot tubbing session, especially if the lawyers are in the room and taking part. There could be an opportunity for counsel to re-examine and re-cross-examine on issues that have already been addressed. So I think that's one kind of concern with hot tubbing from my perspective. But as well as assisting the tribunal in clarifying issues that are unclear, it would give you as the expert and your counsel an opportunity to see where the tribunal's concerns remain. So that would be a few closing points on hot tubbing. I know we're kind of running out of time, but hope those points are useful.
Okay, Mélida?
In the interest of time, I will only say that I agree with everything that's been said, particularly on joint reports. I think no value in it. It's costly if you end up with a report where there are other reports that say, but we disagree on this, that, or the other. I think present them with a framework, answer these questions, do what you can jointly. You're going to issue separate reports anyway.
Okay, I would say that it is painful and very tough to do a joint report. We tried sometimes and we not reach a good point. Okay, I'm not seeing if there is the questions, that there are questions. I can't see in my panel here. I think
there are some questions. Maybe, I don't know, maybe we'll start from the bottom. There's a question for Simon. Do you see that, Simon? I'm starting from the bottom, so I apologize. There probably, here's a question that's popped up to Simon. Do you see the difference, if any, of the work between experts in civil and common law, civil versus common law? I think that was an earlier question, yes. Thank you.
Okay. From an expert's perspective, I don't really see a difference. Not in the evidence that you present as an expert. Your duty is still to either the judge or the tribunal. Your evidence should always be impartial, and you should always maintain that your duty is to the tribunal or the judge that you're presenting to. So from an expert's perspective, I don't really see the difference between acting as an expert in civil or common law. As a qualified expert in a particular field, you have professional obligations, and you should always maintain those professional obligations no matter what jurisdiction you're in. So that would be my comment to that question. Hope that's helpful.
Another one.
Here it's supposed that a contractor accepts an NFC, knows the needs of its design. Shouldn't the evidence, the restrictions not attainable in the detailed design during negotiations? I don't know if I understood it quite well. Do you see the question?
Simon, did you see the question?
Yeah, I did. I just saw it pop up on the screen.
Yeah.
Contractor accepting EPC knows the needs of the design. Shouldn't he advance the restrictions not attained? Well, if there are restrictions that come to light and cause disputes, often in cases the design is being progressed as certain works are taking place. So it can often be difficult to do that, and that's one of the common causes of such disputes, in my opinion. So if in an ideal situation the design is complete before you set foot on a site, but that's often not the case in reality. The design is constantly being developed throughout the duration of the project. So it's kind of difficult to raise such concerns early on. Particularly, if you've accepted and signed a contract already, it's a little bit of a tricky situation.
Okay, I think we are running out of time. So I would like to thank all the speakers for your collaboration, for spending this time with us here in the panel, and sharing your experience and knowledge with us. I would like to thank the organization for the invitation, and I hope seeing you in the next panel. Maurício, Lauro, would you like to add something?
Thank you very much for this very thoughtful discussion that you have promoted, and we hope to see you next year in person in Brazil. And we'll have another panel in 2 days on Thursday at 10 a.m. Thank you very much for your attention.